If you've just lost someone to a preventable tragedy, the last thing you want to think about is money. But when the funeral ends and the bills don't, you realize that the system offers only one tool: financial compensation. We can't bring the person back, unfortunately. And in New York, that tool is brutally outdated. I'm Brett Harrison, a wrongful death attorney with many years of experience helping families turn lowball offers into multi-million-dollar settlements. In the next several minutes, I'll show you how to build a case so airtight that even the stingiest insurer has to pay attention. Because here's the truth: if you don't put a dollar figure on what your loved one did every day, raising kids, fixing the car, cooking meals, no one else will. This isn't just about money. It's about forcing the system to respect what was lost. We can't bring the person back, so this is really our only tool. One moment, you're planning birthdays and graduations and trips. The next, you're staring at an empty chair and a pile of invoices. Insurance adjusters express condolences, then slide across a check that barely covers the funeral. That's not justice. Under New York's wrongful death statute, unchanged since the Civil War, that's right, only pecuniary loss counts. What doesn't count? Love, guidance, and companionship are formally irrelevant. So you must translate every abstract quality of your loved one into something a jury can measure. Can't measure the value of a person. Can't just put it in money. But that's what we have to do. Instead of saying he was a great dad, you have to demonstrate that he spent 2,200 hours helping with homework, time worth more than $165,000 in professional tutoring fees. Numbers, they don't move juries. Adjectives do not either. This rigid rule exists because in 1847, railroad lobbyists persuaded legislators that runaway verdicts could sink their booming industry, and the same lobbying victory has survived ever since. Editorial boards and scholars scream for reform. Bills to widen damages still die in committee. Nothing's changed. Until the law changes, we exploit every dollar-based loophole it permits. Once again, documentation is your steel frame. Begin by gathering tax returns, overtime logs, union contracts, side gig income, and every scrap of wage data. This is not going to bring the person back, and it's not very dignified, I agree. Adjust those figures for raises and inflation. In the case Ramirez versus MTA, projecting a modest salary through retirement produced a $12 million award. Add health insurance, pension contributions, and discounts. Record the expenses your loved ones covered, from car repairs to mortgage or rent payments, to insurance payments, to school payments, credit card payments, because an insurer will never volunteer them. Consider the Gonzalez family. After their mother was tragically killed in an elevator malfunction, then insurance generous offer was $400,000. By quantifying her unpaid childcare, home-cooked meals, baking side business for $4.8 million, we settled 12 times the initial figure. Pause here if you must and jot down every hidden chore your loved one performed. This is not easy and not fun to do. From dog walking, tax preparation, negotiating cell phone plans, the list is endless. That scratch list can become an exhibit worth 5 or 6 extra figures. Caregiver contributions, the engine oil of a household, are just as valuable. Courts let us price every hour of algebra tutoring or lawn care. In the case De Jesus versus Verizon, jurors awarded nearly $700,000 solely for a father's lost advice and discipline. But I think you'd agree with me, that type mother or father's advice is priceless. Treat those services as real income in your demand letter. If your loved one suffered before passing, a survival action becomes their final loud objection from behind the grave. Minutes of pain can translate into thousands of dollars per second. We prove this with EMT report, hospital charts, and expert testimony. In the case Ellis v. Crane Company, 11 minutes of crush injury agony yielded a $1.2 million award. Jurors asked, how do we value a scream? Physicians explained the neural firing of acute trauma. Psychologists outlined the terror of awareness. Facts, not theatrics, drove that verdict. Preserve every voicemail or text from those final moments. I know that's a horrible thing to say, but digital evidence can silence skeptical adjusters. Liability is like a river. One rock dams the flow. 3 rocks make a lake. Each additional defendant brings another insurance policy and budget for settlements. Subpoena maintenance log, employment rosters, and product specs to tie every player to the tragedy. In another case, in a Midtown scaffold collapse, adding the rental company introduced $5 million more in coverage and triggered a prisoner's dilemma among insurers. No one wanted to be the last to fold, so the total payout swelled by 30%. Punitive damages, though rare, are the legal system's flamethrower. Expose any conscious disregard, deleted safety warnings, forged inspection stickers, executive emails saying it's cheaper to pay claims than fix the problem. As terrible as that sounds. In the case Vargas v. Apex Trucking, this revealed skip rest break memos tripled the pretrial demand. Even if a judge later strikes the claim, the threat itself lifts settlement numbers. Deadlines can sabotage everything. In general, you have 2 years from death to file suit, but only 90 days to serve a notice of claim when a government unit is involved. Miss either, and the courthouse door slams shut. Start your stopwatch now. Each week of delay gives leverage to the defense. Turn theory into action. Secure probate letters within 45 days so you can subpoena records and file quickly. Send preservation letters by certified mail within the first month. Hire a private investigator to photograph or video the scene before skid marks, fade, or hazards are quietly repaired. Lock in an accident reconstruction engineer before evidence disappears. Retain an economist, a vocational analyst, and a forensic accountant early. Track every loss, funeral bills, grief counseling, estate fees, because insurers discount what you cannot document. Hunt for products liability angles. Research OSHA violations and build a demand packet so polished it looks ready for trial on arrival. Then set an actual trial date. Nothing scares insurers like a ticking clock. Modern cases live in the cloud. Platforms such as CaseFleet tag every witness, document, and deadline, and AI searchers transcript keywords in seconds. This technology will not replace legal talent, but it can triple efficiency and slash the odds of overlooking the one email that blows the defense wide open. Here is an aggressive but realistic timeline. On day 3, you meet counsel. By day 10, the scene investigation is complete. By day 30, every presentation notice is sent. By day 60, you hold estate letters and autopsy requests. By day 75, your experts are on board. By day 120, the comprehensive demand package lands on the insurer's desk. By day 150, mediation often produces 8-figure results. Now, I realize this is an aggressive timeline. I'm just giving you an example of one, if things are done quickly and efficiently. If it does not, deposition schedules and a trial date follow. Speed combined with thoroughness converts uncertainty into momentum and momentum into money. Defenses are predictable. Adjusters delay, hoping mounting bills will pressure you into settling cheap. So file early and request expedited schedules. They minimize wage growth, counter with union contract, and national wage studies. They claim unrelated health issues cause death, counter with treating physician testimony. Shared fault, hire forensic reconstruction experts. Every defense argument is a cost-saving maneuver. Your evidence turns their savings into your settlement. Money talk may feel crude and fresh grief, so create a business of loss folder and treat each legal task like a CFO, not a spouse. I'm not saying it's easy and it's painful, but you got to do it this way. Accepting full compensation isn't greed, it's a stewardship. Your loved one spent a lifetime nurturing your stability. Your claim extends that legacy. Build an emotional support triangle, a friend to vent to, a relative to handle logistics, and a professional therapist to develop coping skills. The triangle keeps the legal engine running when your emotional motor stalls. Justice isn't a single event. It's a chain reaction you start today and feel for generations. Handle each link with care. When doubt creeps in, remember that your persistence writes the legacy your loved one can no longer shape or write. Keep writing relentlessly for your family's future, and when you're ready for the next step, I'll be there. You've just learned how to demand justice after a wrongful death. Now, let's talk about timelines. Because in New York, even the strongest case can stall if you don't move fast. Tap the next video and I'll show you exactly how long these cases take and how to avoid delays that kill momentum and cost you money.